The third most important constitutional commission about which we would like to discuss, that is the Public Service Commissions as provided under Article 315 Article 2 323 of the Constitution. So the very Article 315 which provides that there shall be a public service commission for the union and a public service commission for each state. So, also, as per class 2 of this article, two or more states may agree there shall be one public service commission for that group of states, and if a resolution to that effect is passed by the house or where there are two houses, by each house of the legislature of each of those states, the parliament may by law provide for appointment of a joint state public service commission or joint commission to serve the needs of the states. So, as regarding the appointment of public commission and as relating to their members, so we would like to discuss one important leading case of 2007, that is Sanjay Kumar Manjul versus Chairman Union Public Service Commission, where the Supreme Court pronounced the Public Service Commission can relax essential qualifications only if it is expressly given power of relaxation by the act of parliament. So, in relation to that, also we would like to discuss another important leading case, that is Ravindra Pal Singh Sidhu versus Punjab Public Service Commission, and the judgment was delivered in 2003, where the Supreme Court expressed in the views of that in connection to that particular leading case, where it was expressed by the Supreme Court in relation to that leading case, where it was expressed that the object of Article 317 is to give protection to a chairman or other members of the Public Service Commission in the matter of removal on the ground of misbehavior, and therefore the function of such determination is vested in the Supreme Court, so that the Public Service Commission may be immune from political pressure. So, also in relation to Article 316, as per the provisions regarding appointment and terms of office of members, we would like to discuss the ruling of the Supreme Court in 2013 in the leading case State of Punjab versus Salil Sablo, where it was pronounced by the Supreme Court that under Article 316 of the Constitution, the governor of a state has not only the express power of appointing the chairman and other members of the Service Commission, but also has implied power to lay down the procedure for appointment of chairman and member of Public Service Commission as it was held by the Supreme Court in this leading case state of Punjab versus Salil Sablo and as relating to Article 317 which deals with removal and suspension of members of a Public Service Commission. There we would like to discuss one important leading case Jai Shankar Prasad versus State of Bihar in 1993 where Supreme Court pronounced the judgment that infirmities under Article 317 Clause 3 Subclass C must be such as to disable the members from the efficient discharge of his functions and must be of post-appointment origin. Where a university professor is appointed a member of State Public Service Commission and is known to be blind, he cannot be removed on the ground of infirmity. Also, in this important leading case, the Supreme Court pronounced that hence the no court can exercise this power even by means of the writ of quo warranto. The determination as to whether a member should be removed on the ground of infirmity is left to the subjective satisfaction of the President as to whether the infirmity is such that it incapacitates the particular member for discharging the functions of his office as it was pronounced by the Supreme Court in this important leading case, Jai Shankar Prasad versus State of Bihar, and as relating to the provisions of Article 320, which relates to the functions of Public Service Commission. And in that connection, we would like to discuss one important leading case, State of Punjab versus Salil Sablok, and it was decided in 2013 by the Supreme Court, where it was pronounced that in an exceptional case, if it is shown that relevant factors implied from the very nature of the duties entrusted to Public Service Commission under Article 320 of the Constitution have not been considered by the state government in selecting and appointing the chairman of State Public Service Commission, the High Court can evoke the wide and extraordinary powers under Article 226 of the Constitution and squash the selection and also the appointment as it was pronounced by the Supreme Court in this important leading case, State of Punjab versus Salil Sablok. And now we'll discuss another important constitutional commission found place in the original document of the Constitution which came into effect or in force in 26 January 1950 is the Finance Commission, so as provided Election Commission, as provided under Article 2, 324. So, as per the very provisions of Article 324 relating to Election Commission, it is the duty of this Election Commission regarding superintendence, direction and control of election. So, it would not only superintend the election to the House of People or the Council of States or the state legislative assemblies also. It would superintends can conduct the election of the President and Vice President of India, and the Election Commission, as per clause 2 of Article 324, shall consist the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix, and the appointment of Chief Election Commissioner and other election commissioners shall subject to provisions of any law made in that we have by the Parliament, be made by the President. So the Election Commission is under the law made by the Parliament, through also the very appointment of the Chief Election Commissioner and the members of Election Commission as election commissioners would be made by the President, and regarding any provisions for its change in addition or in subtraction or in refill, it would be the Parliament of India which is supreme to enact any law relating to the Election Commission. So, in that regard, we would like to discuss certain important judgments. So, the first one is Bhagyodaya Jan Parishad, State of Gujarat, in 2013. The Gujarat High Court pronounced that powers vested in the Election Commission under Article 324, Clause 1 of the Constitution are wide in nature, but it cannot be exercised contrary to the provisions of law, nor should it violate the existing laws. And also, we would like to discuss some other important leading cases relating to election and election commission. So, another one important leading case is S.S. Dhawan versus Union of India, decided in 1991 by the Supreme Court, where it was pronounced that abolition of post of election commissioner by the President and consequential termination of the service of the incumbent of the abolished post cannot be made a ground of action. There is no illegality in such termination of service, as it was held by the Supreme Court. And also would like to discuss another important leading case, that is Dasafa and Brothers, Bangalore versus Election Commission, New Delhi, and it was decided in 1992 by the Karnataka High Court, where it was held. However, while the powers of Election Commission relating to direction and control may be Its adherence must be traceable to some existing law and cannot violate the provisions of any law, including state acts. But precautionary measures which can be taken without violating any statutory provisions would not be illegal. And as it was held by the Karnataka High Court in this important leading case, Dasappa and Brothers, Bangalore versus Election Commissioner, New Delhi. So, another important leading case that we would like to discuss, Narayan versus Purushottam in 1993. The decision was tendered by Supreme Court, so in that leading case, it was pronounced no election can be invalidated on the ground that the election officer failed to comply with the non-statutory directions issued by the Commission, even though they are administratively binding upon the electoral officer. So, these are the important leading cases in relation to appointment, termination of members of election commission and their power of giving direction and superintending elections. So, in that regard, we would like to discuss another important leading case which relates to Article 174 and vis-a-vis Article 324 about their scope, jurisdiction, and application. So, in that regard, we would like to discuss a special reference number 1 of 2002 under Article 143 1 of the Constitution to the Supreme Court, and it was decided in the year 2003. So, where it was pronounced that the provisions of Article 174 are mandatory in character so far as the time period between two sessions is concerned in respect of live assembly and not dissolved assemblies. Article 174 and Article 324 operate in different fields, while Article 174 does not deal with election, which is primary function of the Election Commission under Article 324 of the Constitution. Therefore, the question of one yielding to the other does not arise, as it was pronounced by Supreme Court in 2003 in regards to special reference number 1 of 2002 under Article 143 clause 1 of the Constitution. So, we have completed another two important constitutional commissions which found place in the original constitutional document, that is the Union Public Service Commissions and the State Public Service Commissions, also the Election Commission of India.